Everyone, thank you very much for coming on tonight. On the historic occasion, and the 2 more stories coming to Christmas. My name's Renton. I'm going to be chairing tonight's event. I'm a barrister at Garden Court Chambers, and I'm also a member of SOAS, Influencing the Corridors of Power. So before we get properly going, I'm going to introduce first what that is and what we're trying to do with this lecture series in tonight's event, and then I'll come on to introducing the speakers. So SOAS, Influencing the Corridors of Power, is a group of academics, practitioners, students, etc., all of whom sort of work together and cooperate around the idea of trying to change this hideous high political discourse we have, which seems absolutely stuck at some very strange talking points from which nothing ever moves. We organise events in Parliament, we organise all party parliamentary groups, and sometimes, as in today, we organise events also at SOAS. So in terms of today, this is the second of 3 seminars, all of which are built around the theme of the rule of law. We had one 2 weeks ago with Conor Gearty and Paul O'Connell, which is all, again, still thinking about, you know, what is the rule of law? What is this kind of strange ideological concept? Had there previously been people who'd sort of nibbled away at it or challenged it, for example, during Iraq? That we did 2 weeks ago. We've got another event coming up in 2 weeks' time, which I'll advertise at the end, which is trying to get towards what do we do about attacks on the rule of law. But the whole theme of today is really about what's going on now. How is the government, etc., not just the government here, but how politicians around the world attacking the rule of law? What is it about this moment which is causing that to happen? And today, I'm saying this for the speakers' benefits in case they are rewriting their talk as I speak.
Literally.
But today is intended to be sort of like, if anyone goes further back in time than Brexit, I'll knock them on the head. If anyone looks further forward than, you know, whoever's going to replace Liz Truss, again, I'm knocking them on the head. What we're just trying to think about is this core idea. You go back about 30 or 40 years ago, and actually the defence of the rule of law was a really important part of right-wing, conventional right-wing thinking. And if anyone wants to sort of visualise this, have it clear in their own heads, think about the TV programme Sherwood. And the one clip, the one actual bit of news footage they used from the miners' strike to try and put people in the mid-1980s. And it's Margaret Thatcher getting up and saying, the worst thing about the miners is if they win, the rule of law, that will be broken. That's the worst you could do. And it seems quite extraordinary then to kind of roll forward to our present, where you could have judges being the enemy of the people. You could have governments, ministers getting forward saying, well, we're going to breach international law, but only a very limited, specific one-off way. This seems quite weird, however things change. So we've got 3 speakers to talk about that and so to focus on what's going on now and to help us try and find layers there and things which people maybe haven't seen yet themselves. We have 3 speakers. The first will be Joelle Grogan, who's a senior researcher at UK in a Changing Europe, an independent think tank based at King's College in London. She's also a research fellow at the CEU Democracy Institute, co-director of the Good Law Profs, and best of all, for my view, if it's all right, creator of Sticky Tricky Law. And if anyone in this room is unfortunate enough not to know what that is, please, while she's talking, Google Sticky Tricky Law, because you will see the most brilliant ways of communicating sophisticated and complex legal ideas in a way which anyone can get very quickly. She'll be speaking first. We then have joining us through the online connection, which I'm really hoping will work, but fingers crossed, we have Faure-Walker, a lecturer at UCL and author of a fantastic new book, The Emergence of Extremism, Exposing the Violent Discourse and Language of Radicalization. And then our third speaker is Amanda Weston, KC. Can I just say, there will be some people in the room who've noticed that everyone who was a QC is now a KC. The thing I can say best about Amanda is she's the only KC I know who did not telephone me at 4 o'clock on the day that Lizzie popped her clogs to say, I've got hold of the clerks. I've changed my email address. All my other lefty barrister friends were all getting that changed within minutes. Amanda, I'm very proud to say, seems to have taken it all in her stride. Bless you. She's a leading public and administrative law barrister who's acted in many of the leading judicial review cases of the last 20 years. One for me, because I'm an employment lawyer, McNally, which has set the gold standard for procedural and justice in workplace disciplinary hearings. AHK, which sets out the principles which apply when the Home Office bases immigration decisions on information which it refuses to disclose to the claimant. And she's also acted in many deprivation of citizenship cases. Probably best known to people in here will be the Abu Hamza case, but she's also been in countless other very high-profile cases. So again, it's a pleasure to have all three today on our platform. If I can begin with Joelle, please.
Wait, am I moving? Did I mistake that?
That's fine.
Even better. Hello. Hello. You heard me chatting away earlier. That is partially a function of the fact that this is my 4th coffee today and I haven't actually had lunch, because I, like all of my colleagues, and I have no doubt many people in this room, have been glued to our screens looking at the latest political constitutional crisis in the United Kingdom. I'm not sure if anyone is still aware or still unaware, but we lost a leader of the Conservative Party today. Actually, I'm very aware, because walking over here from King's, every single person that I passed, everyone was talking about Liz Truss, everyone. So today, the reason I'm highlighting that is we seem to be lost in this maelstrom of political change, this maelstrom of politics. And even as we try and shout about what should or could be important issues, like the energy crisis, like the Northern Ireland Protocol, like the cost of living crisis, even as we try and shout for these issues, we seem to be continuously lost in this spectrum of leadership, in a spectrum of who is leading the Conservatives, and will they have confidence of Parliament, that wonderful convention here in the UK. So if I try and take a step back about that and hopefully talk about why I was invited, I'm a rule of law expert. My career, my research, my work is based on the rule of law, on advocacy of what I consider a core principle of legal systems, not only here in the UK, but of liberal democratic legal systems throughout the world. I don't consider this a political concept. I think if we have law, we have certain principles that we must always abide by. When I talk to people on the street, that's a lie. I didn't stop on my way here and be like, let's talk about the rule of law. But very, very simply, the way that I always encapsulate it is that nothing and no one is above the law. Nothing and no one is above the law. So when we have this as a core fundamental idea, from that springs very essential principles that we are very familiar with as lawyers, as legal scholars: the idea of legal certainty, the idea of legality, the idea of accountability to the law. That means that there should be parliamentary scrutiny, there should be judicial oversight, that nothing and no one is above the law, therefore law applies equally, equality before the law, non-discrimination. All of these are core and should be familiar principles that should guide and determine how we act. And when I say we, I mean everyone from the ordinary person on the street to commercial interests to, critically and importantly, the Prime Minister, whoever he or she or they may be. So within the context of talking right now about the state of the rule of law, I have very important insights that I would also echo in the context of how governments, how politicians, how the authorities, and how the public figures that we should expect always abide by these core legal principles, how they actually acted and governed during crisis. So I also work in the context of emergency law and emergency action. How do people respond? How do we govern in crisis? Now, I want to immediately clarify that there is a very significant difference between a global pandemic and the current political conservative crisis that we are seeing. There is a very functional epidemiological distinction between those crises, but nevertheless, what we see is echoes of the same style of governance, echoes of the same decision-making in both the pandemic and the current political crisis, and broadly understood. So what I thought I would do is take an almost walk through the last 3 years. I've been told that I cannot go before Brexit, so I'm going to restrict myself to 2020. And I'm going to take a walk through the core legal principles that we should abide by in the context of the rule of law and how we actually saw them in practice during the COVID-19 crisis. So let's talk and let's start first with those core ideas of legality and legal certainty. Legality, to everyone who is a lawyer or a law student here, can I have a little wave for law students? No law students? Yes, fabulous. Yay, 2 law students in the room. I don't know why I used that accent. I'm so sorry. Legality is very simple. It's that you act within the boundaries of the law. There's no unconstrained discretion, no unfettered discretion. Very simply, MPs, or rather ministers, cannot do what they like, tell you what to do without being bound by the law. There has to be a legal basis for action, that law governs and determines how we should act. I mean, seems straightforward. I'm going to fold also the idea of legal certainty into this. Legal certainty is the idea that you should know the law that applies to you. You should be able to understand the rules that apply to you. You should be able to understand and know and be able to even find out what laws apply. Now, I think we all remember, at least during the first lockdown, potentially during the second lockdown, and certainly during the third lockdown, there was almost continuous discussion as, well, what law actually applies right now? What rules should I be abiding by right now? And within that, we fold so many of the issues that came to the fore that cannot be excused by it was an emergency. For example, the mask mandate was introduced under urgent procedures. That's the idea that we need to do this immediately. We need to introduce this as fast as possible. But that didn't really make sense. But a mask mandate had been trialed for weeks before the sudden introduction of the rule. There was also great confusion as to what is guidance and what is law, what is simply advice from government, and what is a rule that you must follow under penalty of a fine. There was a great deal of confusion. But when we talk about legal confusion, it's not simply, I'm not sure if I can leave my house right now, so much as there is a potential possibility, if not a great likelihood, if I'm from a certain background or from a certain area or for a certain age, that I will be fined, that I could be subject to criminal penalty on the idea of not understanding the law. It was shown, and this is actually something that the Joint Committee on Human Rights raised, that the fixed penalty notice, anyone know what a fixed penalty notice is? Or we all hid in our houses for about 3 months. So the fixed penalty notices of the 85,000 that were given, that 85,000 fixed penalty notices that were distributed in the context of the COVID-19 regulations, they were so discriminatory in their application, they were so muddled in their meaning, and there was such a difference between what forces applied which, when, and where, that the Joint Committee recommended that all of them be found to be, well, inapplicable, that they were all unlawful. But what we can actually talk about, and we can actually focus in on the kind of decision-making and lawmaking process which led to this, we can focus in on the rule of law context that should be applying. And we can say that there is a preference, and we see this preference not only in the Johnson government, but also in the Truss government, as a continuing representation, which is the reliance on Henry VIII powers, the reliance on huge delegated power. Now, saying Henry VIII power, I know if you've just seen Six the Musical, inspires like this great musical interlude, which I won't do because the microphones are over there. But if you're a lawyer, hands out to the law students in the room, talking about delegated powers, and particularly talking about Henry VIII powers, can be quite scary. They are innately quite concerning. Very simply, we come from a position whereby law gives authority, law gives the boundaries and the limits of power that can be exercised. Whereas Henry VIII powers give that power a little bit further. They give power to ministers to change the very limits, to change the very boundaries or the basis upon which that power is given. Very often, and now I can say that this is not only within the context of the COVID-19 pandemic, but we can see it in echo, not even in echo, in amplification in the Northern Ireland Protocol and the retained EU law bill, is this sweeping delegation, the sweeping giving of power from Parliament to ministers. Huge delegation of power to make decisions with very little scrutiny, with very little oversight to ministers. I can take a step further, and this is something that you should definitely look up from the Hansard Society, who have led on this. But there's then a question of giving so much power continuously that leads to a lot of very concerning rule of law elements, not only for the worry that we'll fall into the same unintentional problems of legal certainty, the unintentional problems of acting beyond and outside the boundaries of the law, introducing policy very quickly, or even introducing the justification for policy behind paywalls in a telegraph. True story, that happened. But I know it was 2 prime ministers ago. But also, I'm so sorry, comedy is because I haven't eaten anything today. But also it's showing a lack of trust, or a lack of a trust in the idea that parliaments can pass laws and pass laws well, to debate, to scrutinize, to give due oversight, but also to create better rules, better laws. But it's also resting then on the assumption that ministers will come up with a plan later. And this is something that we keep continuously see. We saw this in the COVID-19 pandemic, and to an extent, we're also seeing it in the Northern Ireland Protocol Bill, the assumption that the plans will come later. We just need to give the powers now. But in this, again, I rest on what was one of the most concerning determinations of the end of the COVID-19 pandemic, that we had this excessive executive dominance. And that while executive decision-making, the idea of giving powers or giving decision-making to governments in crisis is not unusual. But what makes it unusual is that there is no scrutiny to follow it. What makes something democratic is not Parliament making a decision in emergency, but giving due oversight ex post, giving due oversight to make better laws for the next, to make better emergency laws, to make better criteria upon which law is created. I know that's a fluffy way of actually saying that there are principles that should govern how law is created. There are principles that should govern how MPs act and how law is applied. These are core essential principles, not only of the British Constitution, but again, I would say liberal democratic constitutions everywhere. And what we see very concerningly, but not concerning, is the fact that water has just arrived, and I'm delighted for my fellow panelists. But what we see is in this executive dominance and this giving of power, and this power to the executive, power to government, power to ministers, which I doubt will change significantly with the next prime minister, is again uncertainty. It's inconsistency. It's a lack of accountability. It's a worry and a concern in terms of the discrimination, the idea that we do not follow the rules that we create. I haven't looked at the latest odds for Boris Johnson becoming prime minister again, but I would remind people that Partygate inquiry is coming up in November. The idea, again, that oversight, that limits, that power should be constrained is a core element of the rule of law. And within this context, we're not seeing that. We're not seeing this as a core representative element of the current government. And when I say the current government, I say whatever government we've had for the next last 3 years and next 18 months. That was a very dramatic opening. I will leave it there very dramatically, as I say, turning to my coffee.
Well, thank you very much. Now we have Rob. I'm hoping that you can hear us, and I'm hoping that you can join us.
So I can hear you. Can you hear me?
We can indeed, yes.
Great. So thanks very much, and thank you very much for the last 20 minutes, which was suitably bleak, because things are pretty bleak, I guess. The first thing I'm going to do is apologise that I am going to go back a little bit before Brexit, but I think we need to understand a little bit about how we've got to where we are, and there are a few examples that I can cite to that I think are quite enlightening. I think we need to look back to. So I'm going to talk about, specifically talk about the advent of pre-crime, and this has been enabled by the invention, and it is very much an invention, a recent invention, of counter-extremism strategies like the PREVENT strategy that's been rolled out as part of the UK's counter-terrorism strategy. So apologies that this will take me a bit before Brexit, but I'm going to go back to, requires that I talk about 9/11, so this goes back to 2001. I'm then going to go back into the next century, the previous century for a bit, and then I'll come back up to the present. So the thing to note about 9/11 is this, and bear in mind that I'm talking now about an area that the government has specific strategies to address extremism and radicalization. And if you look at political rhetoric, newspaper articles in the wake of 9/11, you won't find the words extremism or radicalization used as just or as explanations for the attacks on the Twin Towers. But if you then go back into our further distant history, into the 1930s onwards, you find extremism used quite frequently in Parliament to describe people calling for self-government government at the fringes of the British Empire. So people in India who are calling for self-government are referred to as extremists. People in Kenya who are asking for demanding the British to be removed from Kenya, where they've got concentration camps where people are being horrifically tortured, are referred to as extremists. Palestinians demanding the British Army's withdrawal from Palestine in the 1930s are referred to as extremists. And then moving forward to the 1970s, people demanding a united Ireland in Northern Ireland are again referred to as extremists as well. But the discourse around extremism had kind of waned a bit by the time 9/11 happened. But it was very rapidly rekindled by New Labour. And by the time of the London bombings in 2005, New Labour had already been working for 2 years on a strategy to counter extremism. And so within an hour of the London bombings, Tony Blair had held a press conference where he announced that there was going to be a new British counter-extremism strategy. However, it wasn't pushed. Counter-extremism wasn't pushed by New Labour. And I know this because I was working as a school teacher at the time. And whenever we saw letters coming from the government saying that we needed to adopt a counter-extremism strategy in schools, we ignored them like every other school in the country because we could see that it would be a disaster to start securitizing children. So there was having been ignored under New Labour, it was then rapidly reviewed and republished as a very different strategy by David Cameron's coalition government in 2010. And I'm going to explain to you how the Prevent strategy was then deployed as a concerted effort to divide and to conquer civil society. And this is a very important process by which our state has been eroded, or in fact, our democracy has been eroded. And this is done in 3 ways. The first way is that, and this has really come to the fore today, in fact, but opaquely funded right-wing NGOs and think tanks like the Henry Jackson Society, like the Policy Exchange, have been working in coalition with Conservative ministers to create research. And I put research in heavy scare quotes because this is not research that has come from within university systems of governance. It hasn't passed ethical approval. And in fact, if you read through any of the reports from the Henry Jackson Society or the Policy Exchange, they wouldn't pass peer review, they wouldn't get published from within a university, which is why they have to be produced by these think tanks, such as the Policy Exchange, which Michael Gove was involved in setting up. So he sets up a think tank, the think tank produces the research, which then is waived in Parliament by members of Parliament like Steve Baker, who's aligned with the Policy Exchange. They'll waive this supposed research and say, look, the research says, for example, from the Policy Exchange, that we need to further criminalize protest, and so that we can tackle environmental protesters. And unfortunately, the lack of research literacy in Parliament means that the opposition don't really have a way of responding to this, which is why so ICOP is so important to have academics briefing policymakers. So that's one way, talking about these NGOs. The other way that civil society has been conquered and divided is by, over the last decade, by the ongoing harassment of Muslim charities. So most notably by the Charity Commission under William Shawcross, who is also connected to my first point because he was formerly the director of the Henry Jackson Society before he was then put in place as the chair of the Charity Commission. And in that position, he sought tirelessly to revoke the charitable status of Muslim charities, to shut down their bank accounts, to hound Muslim charities out of the sector. And the third way, as these charities were being shut down, and don't forget as well, this is at a time of rampant austerity, which has caused the collapse of many civil society organisations. I'm talking here about youth clubs, theatre groups, sports clubs, and things like that. The Home Office over the last decade have been running a project called Building a Stronger Britain Together, which is run in collaboration with MC Saatchi, the largest advertising agency in the world, where they have set up hundreds of fake civil society organisations. And by fake, what I mean is that if you have had to shut down your football club or your theatre group, or even there are a couple of board games clubs that have been supported by them, if you've had to shut that down because your funding has been lost because of austerity, you could go over the last 10 years, go to the Building a Stronger Britain Together at the Home Office, go to that project, and you could ask them for their support, and they would give you funding. They would support your advertising. They would support your web presence, if you agreed to say that we need more counter-extremism strategy. So these three things have happened. We've got NGOs to create fake research to support government policy, the silencing of legitimate critique from Muslim charities and NGOs, and the creation of fake civil society to support the government. So the government have been incredibly effective in silencing, or replacing, I should say, dissenting voices with their own. This is without doubt the behaviour of an authoritarian regime and not a democracy. Though I'd argue that this is even more pernicious than, for example, the autocracy of China. It is done without the knowledge of most of the British population, a process supported by the almost complete failure of British journalists to stand up to corporate and securitising agendas. So this process has resulted in the expansion of notions of extremism and radicalisation, and the state's efforts to police them, to police supposedly extreme ideas. So in effect, a process has been devised whereby the state can police thought. Critical thought is becoming a crime, as demonstrated by more recent calls to expand counter-extremism strategy to target, for example, the far right, and that's obviously targeting the football hooligan kind and not those in Westminster offices, and environmental protesters. Again, this is not the behaviour of a democratic government. A few years ago, and I'm going to just jump around a bit here because I think it's relevant. A few years ago, I was asked to present some of my research into preventing counter-extremism to the Chilean Student Society at UCL. And all these Chilean students who'd come over to the UK thinking they were entering into this liberal democracy looked on aghast as I explained the logic of counter-extremism. And they commented afterwards that even under General Pinochet, there had not been a whole society surveillance apparatus like Prevent, because that's what Prevent is. They've trained 5 million NHS workers and teachers. So as a result, we are all under the surveillance of the Home Office. Whenever you engage with the NHS, your nurse, your doctor, your parents, teachers are all surveying us. So it's not surprising that China and India and dictatorships around the world, from Bahrain to Tajikistan, have lapped up training in counter-extremism from the British government, and they've willingly offered it to these regimes. So this attack on democracy in the UK is, of course, sought to be justified by the government's promotion of an apparent threat to national security. So it's a claim that has been made ever more absurd, especially by today, by the almost daily revelations of corrupt ways in which the government has undermined our democracy and given our state assets to private corporations. National security has also been used to excuse countless other abuses of our democratic rights. Legislation to prevent peaceful protests, preventing the British public from voting in elections with needless introduction of mandatory voter ID, attempted criminalisation of environmental protesters and enabling further drilling for oil in the North Sea at a time when the climate crisis cannot be ignored. Children who've been groomed to marry ISIS fighters have been stripped of their British citizenship and left to rot in refugee camps. Newborn babies dying because of this policy, and continued attempts to deport refugees to uncertain and certainly unsafe futures in Rwanda. And all of this, while Julian Assange, I think we must refer to here, who's perhaps the most effective journalist in human history, sits in a British jail because he revealed the extent of the abuses and war crimes of the UK and its allies. What's perhaps most shocking about these abuses is that they've been carried out in plain sight. They're described in Labour and Conservative manifestos and celebrated in sections of the press and at party conferences. Even most journalists who don't celebrate the prospect of refugee deportation flights or the incarceration of Julian Assange generally fail to scrutinise these gross abuses of human rights. So alongside the intentional and vocal promotion of fascistic policies and the muzzling of the press and the opposition, for that matter, for anyone who saw Starmer's speech to the TUC Congress earlier today, there's another similarity between Chile under Pinochet and Britain in 2022. The founder of numerous conservative news outlets, including Conservative Home and Unheard, Tim Montgomery, tweeted the other day about the election of Liz Truss and the installation of Kwarteng as Chancellor, that this was a massive moment for the Institute of Economic Affairs. That's another shadily funded think tank sitting in Tufton Street. He went on to tweet, "They've been advocating these policies for years. They incubated Truss and Kwarteng during their early years as MPs. Britain is now their laboratory." So much like Chile, where Chile was a test tube for the corporate agendas of the Chicago School of Economics, Britain has become the laboratory for the similar agenda of US-funded think tanks now. So thankfully, the experiment, and with rapid increasing pace today, has been failing. But there's almost certainly more harm to come before a new direction is found. We might not have the torture prisons of Pinochet's Villa Grimaldi, or do we just hide them better with rendition, black sites, Guantanamo Bay, and Julian Assange's years of solitary confinement? But the recent loss of rights in the UK is on a similar scale to that under General Pinochet in Chile. After the election of Chilean President Salvador Allende lost his life to Pinochet's thugs in 1973, it took nearly half a century for a fair and representative government to be elected earlier this year, when Allende's granddaughter was put in as Chile's defense minister. So she now heads the army that oversaw the death of her grandfather and enabled the massive loss of rights and transfer of public assets to private corporations. So this 50-year timescale is what we need to consider, which is why I've gone back earlier than Brexit when we're thinking of political change. So while these might feel like desperate times in the UK, we must focus on what a kinder, more caring, and a fairer society would look like. Like Chile, it might take 2 generations to achieve for our children and their children, but it's quite easy to love our children, so it shouldn't be too difficult, even if it does take a long time. So what do we need to do? The first thing I'm going to say is we need to look at our news sources. So perhaps pay for a subscription service to avoid the bias imposed by advertising corporations, or get your news from not-for-profit commentary like that that's supplied by ICOP. And finally, and you could listen to them much better, they'll tell you much more important things than I'm able to tell you this evening. Listen to the lawyers, as they can tell us what legislation really matters as a guide for what we need to do, where we need to focus our efforts. So it certainly is a long road to something better than the current state of British politics. But this shouldn't be too hard, as we're doing it for our children, as I said before. So a better world is inevitable, and it's inevitable each time we do something that puts profit before people. In doing so, we make a small contribution to this necessary and inevitable change. Thanks.
Thanks so much, Rob. And now, Amanda.
Thank you. It's a strange paradox, isn't it? Having heard what the 2 other speakers had to say, you would think, wouldn't you, that veneration for our institutions would be a key plank of the fantasy of British exceptionalism that has created Brexit and seen Brexit through. So why is it that the current treatment of judges, courts, lawyers, and those who report on the law and those who speak up for the rule of law, why are they being vilified in a climate of British exceptionalism? It's an interesting paradox. I'm not going to talk so much about the laws that Parliament makes, because there's a kind of visibility about those laws. They go through a process. What I'm concerned about more is what's happening in the margins, what's happening in the grey areas. We touched on them this evening already, talking about Henry VIII powers. We're talking about policy making, talking about quite important changes to the laws that bind us, to the structure of law in this country that we never really get to see debated. I'm not saying that parliamentary scrutiny is effective. In the Commons, it's fairly ineffective. It's almost wholly ineffective in the Commons. There are lots of reasons for that. The government of the day has effectively a mandate. When there's a good majority, you get what Hailsham described as an elective dictatorship. What's also sorry, is this not happening? What's more anxious than that is the way that, certainly in the context of very coercive powers, there's quite a studied exploitation of the ambiguities of law. And in the counter-terror and in the counter-terror context that we've just been looking at, that means a shift from sanctions imposed through the criminal justice system to sanctions imposed through the civil system, where the procedural safeguards in place are so much more woolly and harder to enforce. And I'm going to talk about two particular examples, very recent examples, of the way that parliamentary scrutiny has either been bypassed or failed. And the first of those is the use of deprivation of citizenship powers. You can't really get much more fundamental than that, because citizenship, as Hannah Arendt has so often said, is the right to have rights. So without your citizenship, without an effective citizenship, you don't have the means of turning to the state whose task it is to defend the rule of law and to ensure that you are protected by the rule of law. We all remember what Baroness Hale said in the Guy de Mendoza case, that it's democracy that respects the rights of minorities and the vulnerable, even when the majority is failing to. So the first of those, deprivation of citizenship. How can it be that in a parliamentary democracy, Parliament can legislate for a right of appeal against deprivation of citizenship, but when the court determines that an appellant, in this case Shamima Begum, cannot have a fair hearing, there is nothing the court can do about that, and the appeal is stayed. So just a brief run through how we got where we are with the Shamima Begum case. The government in 2006, so it would have been the Labour government, made amendments to the British Nationality Act, which removed the suspensive right of appeal. So it used to be that when a person was being deprived of their citizenship, the order by which the citizenship was actually deprived couldn't be made until the appeal right was exhausted. So that effectively meant that if you were outside the UK or inside the UK, you retained your British citizenship until your appeal right was exhausted. And then in 2006, that appeal right, sorry, in 2004, that suspensive effect of the appeal right was repealed. Why was it repealed? What was Parliament told about why it was necessary to remove the suspensive effect of the appeal? Parliament was told, and this is all in Hansard, that it was necessary, it was a good idea, because then the government, the Home Office, would be able to run deportation and deprivation proceedings concurrently instead of sequentially, and that would be convenient. In actual fact, that's not what's happened at all. The security services have benefited, and it's called operational benefit, from the fact that as soon as a person steps outside the UK, if you deprive them of their citizenship, they can't get back to the country, and so they're summarily excluded. And that is something that Parliament didn't grapple with at that time. They didn't look at what effect the removal of the suspensive right of appeal would have. There was no debate about it. There was no, well, what's going to happen when people appeal from outside the country? What if they're not in a safe place? What if they're in a place where they can't access justice, that they can't make effective use of the appellate procedure? None of that was looked into, none of it was canvassed. There were no safeguards built into it. So now we have the situation where Shamima Begum, stuck in her camp, surrounded by death, having lost all her children to childhood mortality, is now in a situation where a court has determined that she cannot get a fair hearing because she's not safe to give the evidence that she would want to give in her own defence, because she's surrounded by people who wouldn't be happy about the information that she might want to give. She's in danger. There's a judgment online, you can read the judgment in SIAC. What then happened was that the courts were asked to determine whether that appeal was a fair appeal. And if it couldn't be determined fairly, should she be given her citizenship back? And the Supreme Court said, well, Parliament hasn't looked at this. We're not going to fill the gaps. We're not going to make up the law. It's for Parliament to make these procedural safeguards. And that's the situation we're in now, where a failure to grapple with the consequences of summarily removing an essential aspect of a procedural safeguard has resulted in a situation wherein even the highest court in the land is saying our hands are tied. Another example is the recent Rwanda litigation. So the government has determined, and with a great deal of fanfare, that they are going to deal with the arrival of refugees in small boats by removing them to Rwanda, a bit like the Australian offshoring policy. There is no statutory basis for that policy. Parliament has never examined how that would be done. What would be the effect of a treaty between Rwanda and the UK? Who is going to monitor and ensure that there's compliance with human rights, that it's done fairly, that refugees are looked after? There is no statutory basis for any of it. And what the latest litigation has just shown, and it's interesting because in the context of rubbishing law and lawyers and the rule of law, and seeing these essential democratic institutions as somehow being a fetter on the activities and policies of the government, what's important is to note that when the government is rubbishing the lawyers and accusing them of getting them in the way, that it's a win-win for them. If the refugees win, it's a win for the government, because then they say, look at these lawyers and judges getting in our way, let's scrap the Human Rights Act. And then if they lose, sorry, if they win the case, that's fine. They've been off the Rwandan refugees, the refugees to Rwanda, and then whatever happens to them is afterwards is not this government's concern. It's a toxic environment in which to have an argument like that, but it even becomes farce. Part of the argument turned on whether or not the European asylum law and the directives was retained law after the Withdrawal Act. It's interesting to note that Lord Pannick, who was taking the argument for the government on that, was put in a position where he had to withdraw from his previous, from the government's previous position, because up until the Rwanda cases, it had been in the government's interest to say that the provisions of the European law could be relied upon the government because they were retained law. But when they realised that it was inconvenient for the Rwandan for the Rwandan project because the refugees were relying on the directive, they said it was no longer retained law. And because it had always been conceded by the government in previous hearings, and it was an agreed position, that meant that there wasn't an authoritative judgment on it, and so the government was able to resile from the position they've taken in every case since the Withdrawal Act up to now, without any clear, obvious basis, and importantly, not having run it through Parliament. These Kafkaesque and farcical legal results are a consequence of the failure to recognise the importance of the separation of powers, of the task that Parliament undertakes in scrutinising law, and in the task that the judges undertake in saying what they mean and whether they're being applied correctly. I never thought I would sit in a courtroom where I genuinely felt that I was in a bit part player in some huge farce. There was something like 40 barristers in the room, and it's a disappointment to me that the public understanding of what exactly the mechanics of what's happening and how, like almost like a Jenga, pieces are being removed from the fabric of our democracy without the public noticing.
Okay, we've now got plenty of time for questions. I do want to specifically say to anyone who's listening to this online that you're all very willing to ask questions, which you can do either by putting them in the chat or by signaling that you'd like to ask a question. If you do that, we do have the technology and we will let you speak and ask a question directly to the panel. But of course, there are also plenty of people in the room and you too can ask questions. So if anyone would like to indicate in the usual way, please.
So, what you said today, it appears to me, and it has actually occurred to me before, that as I see it, lawyers and people working in the judicial system are concerned about the preservation of the law, rule of law, and how things work. To me, and particularly when we had Boris Johnson, it seemed to be more of a popularity competition. It was less about the rules, it was less about equality, it was less about opportunity for people. And it was more about what the public thought and whether that would keep him in power, whether that would keep him popular. And it seems to me, thank you, it seems to me that they are more concerned about what will keep them where they want to be and less concerned about actual law and the consequences. And as you said, the farcical way that things are discarded or changed. And I just wonder, is that ever going to change? You know, are we forever going to have a parliament that chases a popularity competition as opposed to actually put into place what they're supposed to do, which is the safeguards and all the other aspects of law that are supposed to be protecting the democracy and people within it?
Fantastic. What I might do is I might see if we can take two questions and go and then take them back to the.
Thank you so much. Pleasure hearing from all the panel. I just have a huge question. I actually covered the rule of law as a topic as part of my first year of my LLB. And one constant theme that I've noticed is during this political climate, every time that the rule of law has taken more of an active approach, the government response is to abolish it altogether. And what we've seen is many judges and many lawyers have stayed away from commenting on the government's actions, all based on the idea that their role is to interpret the law rather than check and scrutinize the law. And a lot of they are interfering with democracy. My question is, how can we tackle this issue? What would be the response for us to kind of make, how can we through the law scrutinize governments and make sure they follow without them coming with a solution that we should abolish the law altogether?
Brilliant, thank you. So I'm going to take those two questions and pass them over to the panel. And I suggest we follow the same sequence as before. So Joel, then Rob, then Amanda.
Oh man, popularity. So politics is about popularity. The reason I'm a lawyer is because politics scared me, and now I'm working adjacent to politics. Because the reality is popularity and popular policies in politics matter to law. We have to understand the law in the context of the political climate. We have to understand law in the context of the social economic climate. You can't separate them. But one thing that you're going to, which is the scourge not only of the UK, but it's across the world, is populism. It's the idea that we're having a push towards populist ideologues or populist governance, which also is a lot like autocratic governance. It's the idea of them versus us, like these nasty elites are making all of these decisions and making your life a lot worse. It's not popularity, it's I'm trying to avoid bad words right now because I'm on camera and I'm very aware of that. Hello to everyone listening. But it is something that's deeply concerning, this idea of populism. And I'm going to again go back to what we saw in the VDEM report this year, what we saw in the World Justice Project, which is the demise of democracies, that we have fewer democracies now in 2022 than we had in 2021. There is an increasing movement away from democracy towards autocracy, a movement towards very authoritarian governance, and a movement that is hugely supported by this idea of this is the popular idea. So yeah, so I'm going to actually fold that into the next point, which is the abolition of the rule of law. And I want to actually distinguish something between getting rid of law and getting rid of the rule of law. Because what we see with autocrats, and I'm not necessarily talking about the UK, but autocracy in general, is this use of law in a way that breaks the fundamental principles of it. The use of law against minorities, the use of law to get rid of opponents, the use of law to get rid of the media, to stifle media freedom. To give an example from the COVID-19 pandemic, we saw a law across the world in many, many countries which said you cannot publish any information which spreads disinformation. You cannot publish misinformation or disinformation. That's a crime. And it would be used to target journalists who were criticizing the government approach to managing the pandemic. So it was stopping free speech, but it was under the guise of a perfectly legitimate, perfectly legal legal law. That's one for the rule of law discussions, a legal law. But it's the misuse of law towards populist ideas, but that somehow betray the very foundations of the rule of law, of rights, and of democracy. Solutions to that, well, I mean, as ridiculous as it sounds, an open society, a civil society, a separation of powers, but also just education. The fact that I can talk about the rule of law publicly and that everyone in this room will say, yeah, no, that's an important principle. That's something I'm familiar with. That's something that's important. This education is so fundamentally and functionally important. So that's why I'm giving everyone in this room kudos for coming. You are part of the solution. But it is deeply concerning. It's a deeply concerning aspect, and I will rest back on my foundation of education.
Thanks. Now, Rob.
Yeah, thanks very much. I think just to, briefly, the idea of a popularity competition is there's a bit of nuance to that, because actually what we're seeing is it's a popularity competition, but not for the whole public. It's for the 51st centile, as we saw in the Brexit vote. It's run by focus group. It's run by focus groups. It's run by analytics companies like Cambridge Analytica, so that you're only trying to get that edge yourself over the line to get a mandate, which is deeply dystopian, because it means that you're not trying to. There are no politicians trying to argue a case that will fit to the whole public, to get the public behind them, and they're always failing a significant chunk of the electorate. because the way that these analytics companies and focus groups work is divide and rule. It's always going to be divide and rule, and to get that 1%. And because of that, although on the surface we're living in a democracy, we're actually far less effectively or far more ineffectively governed than other autocracies. Say, for example, China. And this is not a celebration of Chinese autocracy. I'm just going to use it as an example to show how our democracy is failing. And that is that with that 1%, that 51st centile, our politicians are able to claim a mandate. And in fact, it's made particularly absurd by the fact that we've got these multiple prime ministers now who haven't actually faced a general election. But they claim they have a mandate to do all of these things that have been discussed, without popular support. Whereas in China, for example, where you've got a very young population, one of the things they've been demanding is climate justice. China is working to address climate change in a way that is being totally failed by our politicians failing to do in the West. So yeah, it's not. I just think just to point out that there's a slight nuance there. It's not a wholesale popularity competition. We're being carefully managed by analytics companies to divide us and claim that 51st centile.
Amanda.
That's never going to change. There's never going to not be a popularity element to our political representatives. But recognition of how the Constitution functions in its many layers is something which, if you haven't spent time learning about it and you haven't absorbed it through osmosis because it hasn't been very apparent, is something which can easily be dismantled. Things that we don't often think about straight away, like the politicization of the civil service, the ineffectiveness of common scrutiny, the packing of the House of Lords with funders and cronies rather than, as it was supposed to be, experts in their field. All these elements play a part. And I've just reiterate really what was said about education. And it can be very, very simple. And I do this for kids in schools. And forgive me if I'm being a bit patronizing, but if you visualize the democracy as being like a tripod, and it's stable and it's solid, and that's because the three elements of the separation of powers, legislature, the executive and the judiciary, are always in tension with each other, and that the politicians recognize that. They stay in their lane and they accept that there are limits on their power, rather than what I think was a trend started by David Blunkett, which is to rubbish the judiciary when they give a judgment that you're not fond of. That sort of sense of stability is what's at risk. And everybody needs to understand, and children need to understand as they grow up, that that's why we live in safety. Not all of us live in safety, but that's why up until now that our democracy has been as stable as it has been.
Again, looking for questions. Questions can be short. And I'm also interested, I mean, we don't want these events to be everyone agreeing with each other. So if there is someone in the room saying, look, actually, the things which I've heard in the room, which actually I disagree with, that's fine. Indicate, because, we'd like there to be a genuine discussion in the room. Right, so take the striped top, and if someone could. Okay. I actually meant the woman in the striped top, but yeah, why don't we start with that and then the woman in the striped top? Cheers.
Hi, good evening, everyone. Thank you. Just a question in terms of separation of powers. In an evolved democracy like Britain, as a foreigner, I look at it with admiration as a lawyer, I look at it, well, all these laws were enforced on all the Commonwealth countries. All these laws were enforced on pretty much most of the world who looks to Britain as a jurisdiction for any type of dispute you have. You choose England as that common dispute because the chances are, or you reckon that you'll get probably fairness, justice, and some form of equilibrium in the decision or an equitable decision of sorts. So it is, I want to even go as far as saying is that England becomes the bastion of legal precedents globally. You look at America or other more evolved, other equally evolved countries, and the decisions that are handed down in light of Roe versus Wade, you think, God, not ever going to go back there again to choose that as a jurisdiction. So your comments on the destabilization of the tripartite or the separation of powers is one, horribly sad, two, incredibly frightening, and three, what do we do about it? Because if the world is looking to England for precedents of some form, what does that say about dictatorships? What does that say about pure socialist countries where the rule of law isn't separated, where you don't have the luxury of democracy, so to speak? And I'm not asking you for that brush that will make everything right, but some tips in the direction of what should we be advocating for and what small steps. And of course, education is the foundation of probably everything. But I think right now, it's not going to give us any tangible or type of solution that we can say, hey, this is what we should be doing. Thanks.
Thank you. And then the woman here in the stripy top, please.
Or just in front.
Just, thank you.
So my question is, in whose interest is it to keep Julian Assange in prison? Because he's going to die in prison. And why has he received no support from other journalists in the media? I mean, no support whatsoever.
Okay, before I pass those questions over to the panel, I'm going to add a couple of my own. So I'm going to play devil's advocate here. And just to say, I mean, I bow to no person in terms of my central leftness. If anyone wants to have the row here, I will have it outside. But I'm someone who comes from a right-wing family, and a lot of time, a lot of the interventions I make are in centre-right media. So I wanted to at least have that voice in the room, if only to give people some easy ways of knocking it down. But let's go through it. Right. Aren't we all just a bunch of moaning, whingy lefties in this room? Really? Come on. This is fascism. This is Chile. It's not. You know, the Prime Minister has not been killed. We do not have 1,000 people being shot in football stadiums. Or more concretely, and trying to do this way of like joining together the different people who are speaking in the room as a way of like testing out the joins between some of the talks we've heard. And this, the first comment is aimed at the kind of connection between Joel's and Rob's. Look, when the COVID emergency started, a lot of us were worried about, you know, this is like a Schmittian, absolute, it's sovereign, declaring who's sovereign, it's the rule of law discipline. We weren't just thinking, oh God, it'll be bad if a few politicians don't play by their own rules. Yeah, that's a level of badness. But a lot of us in this room, if we're honest with ourselves, had a notion that there was something much worse that might come quite quickly, that the emergency that we'd had under COVID, which of course was a continuation of the emergency from Brexit, we thought this would see a wholesale advance of the authoritarian character of the British government across many different areas at once. The thing is, once you actually look at it deeply though, and think about the examples people are talking about, say Rob's point about pre-crime, being crude here, did the problem of pre-crime get any worse under the pandemic or after the pandemic? No. We had prevent beforehand, we've had prevent afterwards, nothing really changed. A lot of us feared that, you know, there was going to be this new prevent report and that was going to lead to a massive ratcheting up of the prevent attack. Let's be honest, we haven't had the report. So the state of emergency on that spectrum, which is the spectrum people in the room have raised, it would lead to a massive expansion of the use of pre-crime as a sort of criminal assault against the people. Did it happen? Surely the devil's advocate said, no, actually it didn't happen. Other things happened, yeah, definitely, but that didn't happen. Or again, if you take the example of the, and I'm sort of joining up Joel's and Amanda's, what would, you know, an articulate rational Tory say if they were in the room? They'd say, come on, again, you're moaning about things which didn't happen. Under Brexit, the first set of Brexit regulations, I'm sure everyone remembers, we had 64 Brexit SIs, sorry, COVID SIs. After the second, they were all repetitions, essentially the same one, put through the social, essentially the same bit of law again and again. The first one said, in order to deal with the problem of COVID, we're going to give immigration officers and police officers absolute authoritarian powers to lock people in their rooms, to move them to off-site camps. Immigration officers are going to be being everywhere, because there was a notion that maybe what would happen with COVID is there'd be all these foreigners bringing it to Britain, they'd all be diseased. And so immigration would be how you would prevent Britain from going ill. Not one of those powers got used. Was there a massive expansion of the immigration security state under the COVID state emergency? Arguably not. It kind of did happen, but with the Rwanda as the intention, but with quite a long break in between and quite a lot of discontinuity in between. So this idea that we're just sleepwalking to fascism, that the authoritarians are winning in every skill, and it's just getting worse and worse everywhere at once, it isn't the answer, actually. Again, I'm hoping the panel disagree with me, but isn't the answer actually that Britain's kind of survived the worst, and actually what happened is this horrible country, buoyed up by all the benefits of empire, has largely done all right at keeping authoritarianism somewhere else and democracy kind of just about here. Someone tell me I'm wrong, starting with Joel.
Oh man, I really like your, God, if I only had to deal with that, that would be amazing. So many thoughts. Thank you so much for introducing the whataboutery. I love whataboutery. It's great. My gut response was almost to be like, fantastic. That shows that we still have free media. Like, fantastic. That still shows that we have an engaged civil society. Fantastic. But the powers exist now. Like, as soon as you create a power, to quote someone far wiser than myself, it is easier to take power than it is to give it back. But I actually want to tell what happened to me last Monday. Oh my gosh, was it only Monday? Feels like years ago. I was in Brussels. I was talking about the rule of law to the EEA and EFTA, because they fund a lot of projects throughout Europe and the world trying to build institutions on the rule of law. And they wanted me to come and talk about the importance of the rule of law, just to give a really simple explainer. I didn't use Post-its. I am delighted that you noticed about my weird Post-it yellow alter ego. And actually, I love the tripod. That's something I'm going to claim and not cite because because it's a great idea. But no, I was in Brussels, and I was working with close colleagues of mine that I've been working with for nearly 10 years on the rule of law. And one of them is from Hungary, but she had to relocate about 5 years ago to Germany. And she was saying that she was just about to go to Parliament, the European Parliament, and present a report that was written by her and 4 other people in the European Union about a European Union member state and the state of the rule of law. And she was the only person that could put their name on that report, because the 4 others were still in Hungary. And they were too afraid to put their name on a report which talked about the rule of law. That 10 years ago, a year or 2 before I met her, that would never have been a question and never have been a concern. And I know immediately you're going to say, you have just answered a whataboutery argument with a slippery slope argument. Aren't they just equally fallacies of arguments? And yes, absolutely, I totally agree. But in my work, in my research, when I talk about the rule of law, when I look at the trends of democracy, when I look at the trends of autocracy, I always try and imagine the worst scenario. When I see a new power being created and come into law, being passed and made into a statute, I think about the worst. I always think, when a power is created, what is the worst thing that can happen? How badly can this be misused? That's not because I'm a slippery slope kind of argument, but I know that once power is created, once power is given, it is very difficult to give it back, because it is very often in the interest of those given the power not to give it back. So what do I say to that? I have lots of really bad notes. I can't even read my own writing because I type now, and handwriting is a thing of the past. But I would go back to, yeah, so I would actually kind of end the point here on, well, what is the next emergency? Because one of the interesting theories about emergency response during emergency and power during emergency and rule of law is that there is no such thing as a crisis. There is no such thing as a crisis and no such thing as emergency. It's just a scenario that we should have thought about by now. It's just something that we should have prepared for by now. So instead of using quad a battery, instead of using slippery slope, I look to the worst use of a power when it is created. And I think, well, how do we respond to that right now?
Rob.
Yeah, thanks very much. So I think we've got three points to address here. So the first one was, the first question was, someone referred to, which I'm afraid I winced quite heavily at, evolved countries. I find that quite problematic. I don't see Britain or any of the other countries listed as kind of somehow superior in their development to other countries. Britain has forced terrible suffering on the rest of the world through history, from the transatlantic slave trade, famines in India, to the continuing war on terror. And which it continues to export that through the the global oppression of Muslims by delivering counter-extremism training in China, in India. So I just don't accept the premise there that somehow Britain is the superior country. And I also think, just speaking to the rest of the panel, I think that sort of made me think that, I think we need to be careful about being too kind of sort of congratulatory about how great Britain is, even from the perspective of the law. I mean, historically, we have not been a force for good in the world. And this comes on to, and one of the things that we're doing, the second point was about Julian Assange. One of the terrible things that Britain is doing at the moment is keeping Julian Assange incarcerated at Belmarsh, in essentially being very slowly tortured by his, being kept in solitary confinement. And I think I think the intention is to kill him. I think that is clear. Mike Pompeo from the US had briefings with the CIA where they wanted to kill him, and I think the intention still is to kill him. And journalists who I know are probably the friends of mine, who I've had the biggest arguments with about Julian Assange, because I think journalists in the UK, certainly those who I know outside of the sort of leftist media, are the worst for groupthink. And just an example of journalist groupthink, or the groupthink of the press. Austerity is widely recognised to have caused 300,000 excess deaths in the last 10 years. And there really hasn't been much pushback in the press on that. The government introduced a policy a week or so ago, which meant that mortgage rates were going to go up, and people, such as journalists, weren't going to be able to afford to pay their mortgages. The Prime Minister had lost her job within a week because of that. So I think that the press, as much as anyone else, are self-interested, and for whatever reasons, they're not getting behind Assange, and they adopt this kind of circular groupthink of reporting their mates' stories. It's deeply problematic. And finally, to David's whataboutery, I think for me, it is the slippery slope argument. When I was working for ICOP, and the first briefing that we did, in fact, was the against the Coronavirus Act. I stayed up overnight and read the 400 pages, because they introduced it in the evening to then debate and pass the next day, and we got a briefing out on it, and it was simply a shopping list of authoritarian powers. So I would say that we're pretty lucky that we've had such inept government since then, that many of them haven't been enacted. But yeah, they should not be there, and it's terrifying to have those powers in existence. So it is a slippery slope argument, but I think that's a valid argument.
Thanks, Rob. And now Amanda.
Well, full disclosure, I am a tofu munching, fully paid up member of the Wokerati. I've disclosed that. But what I'm talking about is fairly orthodox stuff. I'm not pushing the envelope here. This is very basic stuff. And I think I'm more sanguine than Rob, and there might be a reason for that. And that about the system that we have and how it works when it works. And that's because I do go to court, and okay, I get patronized, I get talked down to by elderly male judges, but honestly, I read John Griffiths. I thought the politics of the judiciary. I was fully ready to take on the senior male public school educated establishment. They were going to be my class enemy, and I was going to have at them. Now they're my heroes. Why are they my heroes? It's because I go to court regularly on behalf of somebody who has zero power. They have zero power in their lives. They can't access what they're entitled to. No one is speaking up for them. And I go and I make an argument. And sometimes that means a good thing is going to happen to that person. And whether it's immigration or whether it's a prisoner, whether it's trying to get an elderly prisoner out of prison and they can't get out because their care needs are connected to their risk. And so they're stuck in prison on an indeterminate sentence into their 80s. And I might get that person out of prison, and that person might go into a care home, and they might take a walk in a park. And they did it because we have a system where there's legal aid available for people in that situation, and I can go and make an argument, and all the time I put into it doesn't get paid for. It doesn't get paid great, but it gets paid. And that is a thing that not a lot of countries have, certainly not in the States to the same extent. And I want to preserve that. I want to look after it. I want to fight for it. And if there are people around that I need to talk it up to, I'm going to talk it up. I'm going to talk it up because it's important and I care about it. And I don't want to be in a situation where I can't help those people.
Thank you very much, Amanda. Now, listen, we've got until 8:30. It is 8:30, so I think I'm going to end it there. Before I do, I just want to well, really one last announcement. This is, as I indicated at the start, only the second of what are, in effect, 3 talks or 3 seminars all around the same theme of the rule of law. If you had advertising for this one, that should give you the link for next. Please do sign up for next, because we'd love to see you at that one too. If you don't have that link, come see me afterwards and I'll find it for you on your device. The last thing I want to say is I'd like you all please to thank our speakers, because I think we've had 3 excellent speeches. They deserve. Well, thank you.